How a lawyer can challenge a drug recognition expert's testimony when you're pulled over in New York on suspicion of drug-related impaired driving. The 12-step protocol used by a drug recognition expert can turn a routine stop into a central part of the prosecution's case. An officer's interpretation of your behavior, appearance, and medical signs influences whether charges are filed and how strong the state believes its case to be. Understanding the process and its weaknesses is critical because each step may add weight to an accusation even when the conclusions do not hold up under closer review. DWAIs in New York are police officers, not doctors, and their authority has clear limits. After an arrest, you cannot be forced to undergo the evaluation, and any significant deviation from the standard protocol undermines the reliability of the results. These officers can only classify impairment into broad drug categories and cannot identify specific drugs or rule out medical causes. Because their testimony is opinion evidence, New York courts require that it be both relevant and based on reliable methods. The state applies the Frye standard, admitting scientific evidence only if the underlying principle is generally accepted within the relevant community, so showing that the DWAI protocol lacks broad acceptance can lead a judge to exclude it. To challenge a DWAI's testimony, a defense lawyer examines whether the evaluation was voluntary and whether each step was performed correctly. Demonstrating that the conclusions extend beyond the officer's training and are based on subjective observations rather than objective medical data can persuade a court to question the testimony. A DWAI evaluation begins when an officer believes drug impairment explains symptoms not accounted for by an alcohol breath test. The protocol progresses through a breath test, review of the arresting officer's observations, medical checks, eye examinations, divided attention tests, assessments of pupils in a dark room, muscle tone checks, and a toxicology sample. Each phase aims to classify your impairment and the drug category involved. However, because these procedures rely heavily on physical measurements and subjective observations, they offer multiple avenues for legal challenge. Common weaknesses begin with the breath test. Failing to observe a 15-minute waiting period or ignoring calibration requirements can skew alcohol readings, yet officers may still proceed with a drug evaluation. When the DWAI interviews the arresting officer, reliance on secondhand information and emotionally charged descriptions may prejudice the evaluation. Physical checks, such as pulse and blood pressure readings, are affected by the stress of being detained and by existing health conditions. Eye examinations depend on the officer's technique and the environment. Moving the stimulus too quickly or inconsistent lighting can distort pupil or nystagmus findings, and inner ear or neurological conditions may mimic drug impairment. Divided attention tests, like the walk and turn, are vulnerable to factors such as anxiety, uneven surfaces, injuries, or fatigue and may not accurately reflect impairment. Later vital sign and muscle tone checks are highly subjective, and a lawyer can argue that anxiety, physical fitness, or cold weather explains abnormal readings. Statements you make during the evaluation may be involuntary because of confusion or fatigue. Officers may filter comments through a preconceived belief that you are impaired, and video evidence can contradict their written reports. The final opinion offered by a DWAI is a summary of subjective tests, not a medical diagnosis, and discrepancies between that opinion and laboratory findings can significantly weaken the prosecution's case. Even the toxicology sample is subject to challenge if there are gaps in the chain of custody or issues with laboratory protocols. A thorough defense attorney uses these weaknesses to show that DWAI testimony lacks reliability and should not dictate the outcome of your case. At the Kugel Law Firm, Rachel Kugel has devoted more than 20 years to DWI defense. Our law firm systematically reviews each step of the DWAI process to identify procedural errors and alternative explanations. If you are facing a DWI or DWAI charge in New York, consult a lawyer who understands how to challenge unreliable testimony and protect your rights. The Kugel Law Firm is at 111 E 125th Street 2nd FL, New York, New York, 10035, United States, and the phone number is 212-372-7218. Speaking with an attorney can provide clarity and help you build a strong defense.